Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. طبعا مساءكم بالخير مستمعينا في كل مكان، ونرحب بكم في هذه الحلقة الجديدة من برنامج يور رايتس مع المحامية جومانا كيروز، وعلى الهواء مباشرة نستقبل اتصالاتكم وأسئلتكم في موضوع الحلقة اليوم. وبالتأكيد الأرقام في الاستوديو كالمعتاد هي 313-769-6666 519-256-1023، ودائما على الواتساب 313-327-7074 للمشاركة معنا عن طريق الرسائل الصوتية والنصية. أيضا مكاتب المحامية جومانا كيروز تستقبل قضاياكم المتعلقة بالإصابات الشخصية من ضمنها حوادث السيارات، قضايا إصابات العمل، الأخطاء الطبية، قضايا الهجرة والتجنس، قضايا الإفلاس والضمان الاجتماعي وقوانين العائلة. للحصول على هذه الاستشارات المجانية بإمكانكم الاتصال على الرقم 248-557-3645، وأيضا بإمكانكم متابعة هذه الحلقات من برنامج يور رايتس على اليوتيوب. كل ما عليكم هو زيارة قناة جومانا كيروز على اليوتيوب والمشاركة فيها والضغط على زر التنبيهات ليصلكم كل ما هو جديد. تحياتنا لكم. جومانا مساء الخير ونرحب بك في برنامج يور رايتس.
مساء الخير رامي، يعطيك العافية. كيفك اليوم؟
الله يعافيك، الحمد لله. نسأل عنك إن شاء الله بخير.
كتر خير الله. مساء الخير لكل المستمعين، مساء الخير لضيفتنا لليوم المحامية ماريا بانشينكو. Good afternoon, attorney Maria Panchenko. How are you today?
Good afternoon, Joumana. Good afternoon, Rami. I'm doing well. How's everybody?
That's good. That's good. Today we will be talking. We're going to start very quickly with a couple of very interesting calls we had in the office recently about grandparents who wanted to know what their rights are in seeing their grandchildren because the other parent is not letting them see their grandchildren. It is something we did talk about a couple of times in the past, grandparent rights, grandparent visitation rights. We're going to talk about it in greater detail today. However, the rest of the show will be dedicated to a number of calls that we have been getting in the office lately because of the new laws that have passed as it pertains to expungements and automatic expungements. So we have had a number of people call our office and seek our help to see whether they qualify for having their misdemeanors and or felonies automatically expunged under the new law. Let's start with grandparents' rights. Tell us about the first grandmother who called and what her scenario was, and tell us about the second grandmother who called and what her circumstances were.
So the first grandmother who called was a paternal grandmother. So she was the mother of a son who had 2 children, actually. And her son was incarcerated in another state and had been incarcerated for a number of years. Oh.
In prison.
In prison, yes. He was in prison for a number of years. It seemed that in the beginning of his incarceration, the mother of the children was okay with grandma and grandpa coming and seeing the children pretty regularly. It would seem that also the mother of the children was continuing to maintain a relationship with their son while he was incarcerated or in prison. And when that relationship stopped and she ultimately moved on, she decided that she would no longer allow the grandparents to see the children. And it seemed to taper off, but ultimately it ended up with no visits at all, no contact. And of course, the grandmother, being the grandmother, was reasonably upset and wanted to know what she could do, if anything. And, there's this common misconception that most people say there are no grandparent rights in Michigan. And that's because some time ago, there was a very, very huge shift where they extremely limited rights for grandparents. So it almost feels like there are no rights. But in her set of circumstances, she falls into one of the very few categories that still exists for grandparents to see their grandchildren if they're being denied. And that is that her son was incarcerated. And when your son or your daughter is incarcerated and they have children and you're being denied access to those grandchildren, you do have rights to seek a relief from the court to see your grandchildren. And it is in the best interest of the children to, most of the time, not all of the time, of course, but most of the time, to maintain that connection to their paternal or maternal side of the family when their parent is not available to them. So I did, of course, advise that she would be able to file a motion. In this case, these two people had an open case out of the Wayne County Court. And so she would, as the grandmother, be able to interplead or intercede on her own behalf, using that case as a motion to file for grandparenting time. And I think that she would be very successful because, there was a pattern that was established in the beginning of him being imprisoned, that she was allowing contact and continuing a relationship with the children and their paternal grandparents. And I think that she would have a very strong case for some visitation with those grandchildren to be able to see them.
Maria, there was a case, if I remember, that you had sent me that I believe came down from the Michigan Supreme Court regarding grandparent rights. Do you remember the name of the case?
DeRose versus Rose.
What is it?
DeRose versus DeRose. The DeRose case.
The DeRose case. That is a Michigan Supreme Court opinion. So that's law in Michigan. And in that opinion, as I remember having read it about maybe 6 months to a year ago, there were very limited grandparent rights. Grandparents did not have rights by law to see their grandchildren unless, a number of things, like every rule, there are exceptions. And one of them happens to apply to our first caller if this grandparent is the parent of a child who is incarcerated. So in this case, the grandmother's son is incarcerated. The son's wife or ex-wife did not want to have the child see the grandparent, but under the DeRose versus DeRose, the grandparent had all the right to have visitations with the grandchild because her son is incarcerated. It's almost, it seems to me, like the public policy behind it. Bad enough the child cannot access the father, let them access the blood relatives of the father who happens to be the mother of the father or the father of the father. Does that kind of make sense?
Yeah, you hit the nail on the head. In fact, they reason that right in the opinion that they should be allowed to maintain. Should it be in the best interest? Of course, there are particular circumstances that would, if the grandparents are not good for the child, if there's something going on there. But for the most part, if they're just, innocent in the reasoning of the child not being able to see them, they're not on drugs, they're not, abusive, they're not disparaging the mother. There's no reason why not to keep that paternal bond with the father's side of the family. And it's fact specific. You might not get a lot of time, but you're going to get something. You're not going to be completely cut off from your grandchild. The court will do something for you. And it depends on how involved you were in the child's life. They're going to, once you get into the court system, Joumana, and you actually file the motion and you do qualify under one of the 4 reasons for grandparents to have visitation, the court's going to look to a lot of factors determining why the grandparent should or should not have, or how much time they should have. And one of those is, what was the relationship before the man was incarcerated? What was the relationship after? In this situation, as I explained, the mother was allowing some visitation after the incarceration, but only after she ended her relationship with their father did she stop allowing them to communicate with their grandparents. They're going to look at all that stuff, but it's not the easiest case to win on its face, because there is a presumption in the law that parents are the best ones to make the decisions for their children. And if the parent decides not to allow the children to see the grandparents must overcome that presumption as to why it's still in the best interest of the children to see them. And if there's nothing sinister going on in their household, and there's no real reason to say no, the court's going to likely give them some time. How much time is going to depend on what was the relationship and how involved were they before in the child's life.
Okay, let's talk about the second caller, the second grandmother. What were her circumstances?
So her circumstances were a little bit different. Her circumstances were, she was also the paternal grandmother. So her son had children with a woman. These people were never married, but they did have children together. And they were separated, and the father of the children was not incarcerated. He was out in public, and he had some very limited parenting time through the courts to see his children. Then the grandmother, his mother, had reached out to the mother of the children and wanted to spend more time with the children, had consistently been asking to see the children, to have them over for events outside, above, and beyond the father's parenting time schedule. And it wasn't in an effort to allow the father to have more time. It was truly in an effort for her to see the children on her own. And the mother denied that request time and time again. So unfortunately, in this set of circumstances, while albeit the grandmother, his most dire wish was to see her grandchildren more, there's nothing that can be done in grandparenting time rules and laws, because the father of the children didn't fall into any of the categories required by statute, or by law. And so she didn't have a case to bring forward for grandparenting time rights. So she was kind of at the mercy of the mother who was denying her the extra time, and at the mercy of her son, really, who it's incumbent upon him to, during his parenting time, allow his children to spend time with extended families. So the court kind of depends on that parent to allow their children access to the extended family. And if he wasn't doing that, or he wanted more time with the children so he could do that, then he needed to file the motion on his own behalf to get more parenting time if he was, in a position to do so, in order to get his parents more time with the grandkids, because there's nothing that the grandparents could do in that case.
Okay, so when you spoke to the first grandmother, you had good news for her. When you spoke to the second grandmother, under the DeRose versus DeRose Michigan Supreme Court, her son's circumstances did not fall within the exceptions mentioned in the DeRose versus DeRose article. The son was not incarcerated. The son was not in prison or jail. The son was not mentally incapacitated. The son was not deceased or dead. And the son was not in a persistent vegetative state. So the grandmother in the second scenario could only hope for the kindness and mercy and generosity of the mother of the child, but she had no recourse to the law.
Correct. Yes, there was no recourse under the law. And, the 4 circumstances that you mentioned are exactly right. That those are the only ways that a grandparent is going to have the right to get the courts involved when they're being denied access to their grandchildren. And it doesn't come around all that often. I mean, gratefully, we don't want to see deceased, we don't want to lose our children and see them in prison. So, what comes up the most when this is happening is that incapacitation, what qualifies as incapacitation. So sometimes there can be some people that try to bend the language to fit into that category. I've seen it where people will file the motion because their child is a drug abuser, and they are trying to qualify under the incapacitated. They're incapacitated because of their drug abuse, and I've seen that is not successful. In fact, I had a case just like that. And it went to trial, and it was not successful. So really what they mean by incapacitation is, you are either under the care of a guardian, you are institutionalized, or like you said, persistent vegetative state, comatose, and truly you're already almost gone. You know what I mean?
Sure. We have a question that is very related to the topic, having to do with grandparents. It's a little bit different. It's not a right by law. I think it goes, and I will let you answer it, of course. I think it goes to always the best interest of the children. Even with grandparent rights, the Rose versus the Rose case is based on the best interest of the children. And here too, I think the court will apply that. Amina's question is, when can a court, or what are the circumstances under which a court will listen and take into account children's desire to stay with their grandmother or spend more time with her or even live with her?
Yeah. So that's definitely a frequent conversation that I have to have with potential clients because, grandmothers, and I could speak from personal experience, they're usually very involved in their grandkids' lives. And, so it's heartbreaking if they can't see them, and for the children too, especially if the children are old enough to voice an opinion, like Amina's question is, that they would prefer to see their grandmother, or they would prefer to even live with her. Unfortunately, the problem here is that if you don't fall into that category or any of those categories, you don't have access to even get the child in front of the judge to say those things. If the judge will allow or consider the testimony of a child, dependent, of course, Joumana, on the child's age and such. But that's the catch, is that you've got to be able to have standing or a right to come into court in the first place and file that motion to be able to get the child to say what it is that their preference is. The option that I usually give to people, if the circumstances fit, is that if the children are not best served by staying with their parents, if they're in several cases, drug abuse, CPS investigations, neglect, or something along those lines, there is another alternative outside of grandparenting time rights that is available to grandparents, where they can go in and file for guardianship if one of those circumstances apply. There's some other I don't know how much you want to get into all of the different details, but there's a lot of different ways to file for guardianship. There's a lot of rules surrounding it if you are a grandparent. And in that case, if you are awarded guardianship, then the child can come and live with you. But of course, just like you had said earlier on the show, you got to fit into the category. You got to fit into the law and the definition of what makes you eligible to apply for these types of things. But unfortunately, directly answering Amina's question is they won't take that into consideration unless you first qualify under the grandparenting time rights or categories and get in front of a judge. But if you do, and you do get in front of a judge, if the child is old enough, it is possible that they will hear from that child and take into account their preference. Now, it's not an overriding decision. The child doesn't get to decide. The judge just takes it into consideration amongst all of the other things that they're being presented with in evidence.
One thing we need to tell our listeners is that generally judges do not like parents bringing their kids to court and testifying and all of that. That rarely, if ever, happens. And when that happens, it's in a very controlled and safe environment for the child. It's not in an open courtroom, correct?
A lot of times, depending on the age and depending on the judge, but the judges have very often sided with the in camera, where they will have the child in chambers. They feel more comfortable. They're not wearing the big black robe. They offer them something to eat and drink, and they sit and have a conversation. And then there's other situations where they have a friend of the court investigator who has been trained to interview children, conduct that interview at a friend of the court investigation they may or may not order. So yes, you're right. A lot of times you won't have to subject the child to testifying right in front of their parent. However, I have seen it done. It has been done. It's just, it's more and more coming out of practice for a lot of judges.
Sure. And occasionally I have seen divorce judges or family law judges, order neuropsychological evaluations for the children.
Many times, yes. That's actually becoming more and more of a trend because as you know, and we've talked about on the show before, Michigan is really becoming a 50-50 state. And so when the parents are trying to overcome that and not have 50-50 custody for one parent, most of the time, in order to get past that, they have to present some very grandiose type of evidence that it's going to harm the child. And a lot of times they will allege that, it's mentally or emotionally not in the child's best interest to spend that much time with the other parent. And so when these types of facts are being presented, many times a psychological evaluation of the child will be ordered to determine whether or not that allegation has any merit.
Okay.
And many times of the parent too, Joumana. They'll order it of the parents as well.
Oh, yes, you're right about that. I forgot about that. Maria, we have a question from a gentleman who is concerned about his ex-wife taking their children to her parents' home where the environment is not very good. He believes that the children are being bullied, they're feeling disrespected, and they are uncomfortable when they are with her family. I assume that this ex-husband and ex-wife have a custody arrangement, and ex-wife has her time and ex-husband has his time. What can he do about his concerns about some of the time the children are spending with the ex-wife and getting exposed to unacceptable conditions, or let's say the ex-wife brings a man into the home or things of the sort? What can he do?
Well, this is a great question. This comes up a lot as well. There is something
in one form or another, you have the ex concerned about what the other ex is exposing the child to, whether it's people or things, right?
Yeah, absolutely. This happens all the time. And it's not uncommon that, especially in divorce situations, that family members tend to side with their child. So if it's, his ex-wife's parents and, they're on her side, and they tend to badmouth dad, and they tend to say things they shouldn't. And this happens all the time. If it's something that's to this level of extreme that he's suggesting that the children are being bullied, or being disrespected, and the children are very uncomfortable, he does, as the parent, have a host of rights to intervene on his children's behalf. And the first thing that I would suggest to him is filing a motion for restriction of third parties. And essentially what that means is you file a motion with the court, the judge that did your divorce, if they're still on the bench, or whoever took over. And you're basically asking the judge to say, this is what's going on during my ex-wife's parenting time. It is unacceptable, and it is hurting my children. It's not in their best interest to any longer be exposed to this type of behavior. And at this time, I'm asking that the court intervene by saying that my ex-wife cannot bring the children during her parenting time to so-and-so's house, or they cannot be present during her parenting time. If it is grandma and grandpa, it might be a hard burden to get to. So in the alternative, I always recommend asking for parental cooperation. And what that means is the wife is subject to the contempt powers of the court should she not stop the behavior of the third party. So if the third party is coming in and bullying the children, talking bad about dad, saying things that they shouldn't, that's inappropriate in front of the children, the wife it's on her duty to either eliminate the children from the situation, leave, or ask the people to leave that are creating this chaos, or to stop it and tell them they cannot speak like that in front of the children. If that doesn't happen and the children come back, they're old enough to report back to dad and they say this is still going on, then she's now subject to the contempt powers of the court and may be show caused. And with a show cause, she might be sanctioned monetarily, or she might even face some time in jail for violating that order. So those are some different avenues that he can take in order to ensure that his children are no longer being subjected to this type of behavior by the extended family. In many cases, this motion will end up in a situation where you are getting in front of a friend of the court investigator who's going to dig a little deeper to see if these claims are really true. And if the children are old enough, they will likely interview the children.
Right. I was going to say that how do you go about proving that the ex-wife's family is doing the behavior? And you're saying that a friend of the court will get involved, will talk to the children, may talk to family members as well to see how meritorious these allegations are. But you've also said something I've never heard before, is that the judge may enter something called parental cooperation, meaning
Yes.
that the ex-wife is now on notice that if the next time she takes, so in essence, the judge is not telling her not to take the children to them, but now she's on notice to make sure that if she took the kids back to her family, they cannot disparage the father, they cannot bully the kids, they cannot be disrespectful. And when she sees that happen, she must stop it immediately, either by leaving or by standing up for it or by asking them to leave. If the children come back and tell the father that this behavior is continuing, now the duty is on her to prove that this is wrong, because if it's not, she's in violation of a court order and she will be viewed as in contempt of a court order, which carries money fines and the possibility of jail.
Correct. And parental cooperation orders, sometimes in contentious divorce situations, are put right into judgments of divorce. They're anticipated. So it's not an uncommon tool that the court uses for contentious and especially litigious files, the files that are going in and out of court all the time. He talks bad about me, she talks bad about me in front of the kids are upset. So the court is doing this a lot, where they're saying, okay, well, now you're subject to the parental cooperation order of this court. And it's, it's very lengthy and it goes over every single different type of thing that you can do wrong in front of the kids. And if you do it, you're going to, suffer the consequences should that come out and that other party show cause you.
If you put it in a judgment of divorce, do you specify parental cooperation as to what exactly?
Yes, it's very lengthy. So it will have its own title inside of the judgment of divorce, usually right below the parenting time.
Yes.
Yes, and it will be very specific. They usually read almost the same in all the courts. But it's just as you described earlier: no disparaging, no disrespectful comments, no swearing, no corporal punishment, no implementing different rules. It just a host of different things that go into it. It basically, at its very bare minimum, say you need to respect the other parent and respect the other parent's involvement in the child's life. And you need to respect the children so much so that you do not ever say or allow anyone else to say a bad word about them.
and that applies to both parties signing the divorce agreement. Would parental cooperation language also potentially include you cannot bring a person, you cannot bring the people you are dating into the home, you cannot, whatever it is, would that also be, can be included?
Actually, that would fall under its own category, and that would be more along the lines of my first recommendation, which is the restriction of third parties. And yes, that can be put right into a judgment. But if you are motioning court and it's not in your judgment, you can ask for that relief if it's becoming a problem for the children, or it's not in the best interests of the children. I've done several of these where we've had to restrict boyfriends and girlfriends. A lot of times, people will agree beforehand that they will not introduce new romantic partners to the children for a period of time, and that does go right into a judgment. But it is a separate from the parental cooperation order. They don't normally include that restricted third-party language. They are separate.
Okay, so they're not part of the parental cooperation paragraph.
Correct.
Okay.
It would be its own paragraph where it would say something probably right below the parental cooperation language if it's there in the judgment, and it would say something along the lines of the title of restriction of third parties, and it would have the language that, you know, they either agree not to introduce new romantic partners to the children for a period of 6 months after dating, or at all. Until they're married or engaged. They will not move people in. A lot of people like to add that language. There will be no live-in boyfriend or girlfriends. They can get as creative as they want.
No overnight.
No overnight visits. Absolutely. Absolutely. And I've had a couple of orders just like that where, you know, people are living together and their boyfriend or girlfriend during their parenting time has to leave the house for the weekend, or they can't spend the night.
Mm-hmm. Very good. Okay, let's take a very quick break, and then when we return, we're going to talk about the new laws that just went into effect in April, the new automatic expungement laws, which allows people without doing anything to watch their criminal record become clean. When does that apply? How long does one have to wait? Are there exceptions? And so forth and so on. We'll have 25 minutes to discuss automatic expungement laws after the break.
مكاتب المحامية جومانا كيروز تتمنى لكم السلامة في ظل انتشار وباء كوفيد-19. المحامية جومانا كيروز مثلت على مدى 22 عاما ضحايا حوادث السيارات مع طاقم من المحامين ذوي الخبرة، وحصلت لموكليها على تعويضات بمئات الملايين من الدولارات. قبل أن تختار المحامي الذي سيدافع عن قضيتك، دقق في تاريخه المهني. ومع مكاتب جومانا كيروز ستنذهل بآراء مئات الموكلين وخبراتهم الإيجابية في جوجل ريفيوز. مكاتب المحامية جومانا كيروز يتحدثون لغتك العربية والكلدانية. 248-557-3645 والاستشارة مجانية. قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية. 248-557-3645. Your Rights مع المحامية جومانا كيروز. عودة إلى برنامج Your Rights. أرقام الهواتف في الاستوديو للمشاركة معنا على الهواء 313-769-6666 519-256-123. دائما على الواتساب 313-327-7074. جومانا نرجع لك.
نكمل مع المحامية ماريا بانشينكو، اختصاصية في قضايا الفاميلي لو وكريمنال لو، القضايا الجنائية، الجنح بعد المخالفات السيرية. رح نحكي هلأ رامي عن قانون بلش بأبريل واللي كتير عالم منتظرينه. حكينا بالماضي لهيدا القانون مهم جدا، وحكينا بالماضي لهيدا القانون منصف. وحكينا بالماضي إنه better late than never. هذا القانون كان لازم يصير قانون من سنوات عديدة، لأنه قبل ما يمرق هذا القانون نادراً ما كان إنسان يكون عنده جناية أو جنحة ويقدر يمحيها من سجله. يعني بتروح لحتى تقدم as a landlord tenant، بدك تستأجر بيت، بتروح بدك تاخد جوب، بتروح بدك تاخد لون، أوقات بالمدارس. من أول الأشياء اللي بيطلع عليها هو الكريمنال ريكورد تبعك. إذا بيلاقوا شيء بالكريمنال ريكورد تبعك مش على ذوقهم، حتى لو تاريخه من 20 سنة، بيضلوا يجيزوك اليوم ويتحفظوا تجاهك وما يوكلوك، ما يخلوك تستأجر، ما يخلوك تشتغل إلى آخره إلى آخره، لأشياء ارتكبتها أنت من سنوات عديدة، ومن وقتها السجل تبعك نظيف وبعدها عم بتبين على السجل تبعك. هذا القانون منصف جدا، لأنه القانون اللي قبله كان عم بيجازي العالم على أشياء ارتكبوها من سنين عديدة، وما في شيء كانوا بيقدروا يعملوه لحتى يشيلوا هذه الجريمة أو الجناية عن ملفهم الكريمنال باك جراوند. القانون تغير، القانون تغير، وابتداء من أبريل صار في شيء اسمه automatic expungement، اللي هو بلا ما الإنسان يعمل أي شيء، بلا ما يستعين بمحامي، بلا ما يدفع تكاليف المحامي، بلا ما يمثل حاله، اوتوماتيكلي بعض الجنايات وبعض الجنح إذا كان عمرها أكثر من وقت معين منها لحالها بدها تنمحي. يعني الإنسان أولا بيستفيد إنه انمحيت وقت اللي بالماضي ما كانت تنمحى، وبيستفيد إنه منه بحاجة لمحامي لأنه it will be automatic. بس هون طبعا في شروط. أول شغلة، هذا القانون الجديد بيقول إذا كانت جنحة بده يكون على القليل مرق على الجنحة من وقت ما أنت عملت السنتنسينج تبعك، يعني الجزاء تبعك، على القليل 7 سنوات. يعني نحن اليوم 2011 ما فينا نرجع لأي جنحة من بعد 2014، بدك تعد 7 سنوات لقدام. ليلي ارتكب اليوم جنحة بال2014، نحن اليوم 7 years later، إذا كان السجل تبعه، هون شرط كتير كبير، إذا كان السجل تبعه نظيف بين 14 واليوم 21، صار أوتوماتيكلي هذه الجنحة منها لحالها رح تنزال من السجل تبعه. إذا كانت جناية مدة الانتظار هي 10 years، 10 سنوات. نحن اليوم 2021 عم نطلع على الجنايات اللي تم السنتنسينج تبعها بال2011. 2012 ما بيمشي، 2013 ما بيمشي، 2011 بده يكون مارق عليك على القليل 10 سنين من وقت ما تقصصت بسبب هيدي الجناية، والملف تبعك بعتذر، ومسيرتك كانت نظيفة وجيدة وما في عليها أي جنحة أخرى أو أي جناية أخرى آخر 10 سنين. ما بيكفي يكون عمرها 7 سنين إذا كانت جنحة أو 10 سنين إذا كانت جناية، بده يكون سجلك نظيف during هال7 سنين أو هال10 سنين، وإلا ما بتكون مؤهل. وطبعا رامي مش كل جناية رح يصير عليها automatic expungement إذا مر عليها 10 سنين، ومش كل جنحة رح يصير عليها automatic expungement لأنه مر عليها 7 سنين ولأنه سجل الإنسان نظيف. مثل كل قاعدة في استثناءات، هيدي لو شو ما صار القانون ما بيتطبق لها. هلأ ليلي اوتوماتيكلي ما بيحق لهم بالقانون الجديد، هيدا ما بيمنعهم حسب شو هي الجنحة أو الجناية. نحن عم نحكي بطريقة عامة، هلأ ما بيمنعهم إنه يوكلوا محامي ويقدموا written application قدام القاضي، لربما القاضي بيرفق فيهم وبيأمر إنه هذه الجنحة أو الجناية تنمحى من ملفهم. نحن اليوم فقط عم نحكي عن الأوتوماتيك expungement، لأنه القانون اللي تغير من 6 أسابيع هو بس للأشياء اللي بلا ما الإنسان يعمل شيء عليها بدها تنمحى منها لحالها. يعني اليوم موجودة بكرة مش موجودة. ما عم نحكي عن الأشياء الأخرى اللي يمكن الإنسان بيقدر يوكل محامي ويقدم طلب قدام القاضي. الأوتوماتيك إكسبانجمنت، هلأ في كتير عالم اتصلوا فينا بهذا الموضوع، ولح أطلب من المحامية تحكي عن هذا الموضوع، بس في كتير عالم اتصلوا فينا مفكرين إنه لأنه طلع القانون بأبريل 2021 وكان عندهم جنحة بالأبريل 2014 يعني خلص راحت. السيستم very crowded. عم بيقولوا هلأ حصلوا على فندنج إضافي لحتى يوكلوا موظفين أكثر ليشتغلوا على هالملفات. عم بيفتحوا كل ملفات العالم اللي عندها سجلات جنائية ليشوفوا who qualifies and who doesn't. بيتوقعوا أنه قبل تقريبا 2023 أكيد في عالم رح تبلش تشوف don't get me wrong، بس بيفتكروا أنه ما they're not gonna get caught up للحقيقة لحد تقريبا 6 2023. So yes القانون بلش بأبريل، وبوقت مثالي مفروض ابتداء من أبريل 2021 كل جنحة كانت من بعد قبل أبريل 2014 أو كل جناية قبل أبريل 2011 تنمحى. عمليا هيدي بدها شغل والسيستم is not set up، يعني بعدهم عم يشتغلوا على السيستم. ولاية ميشيغان عطتهم مصاري إضافية funding لحتى يكون عندهم أكثر resources لحتى يعجلوا بهيدي الأمور. Attorney Maria Panchenko, the first thing we want to tell our listeners is that yes, the law passed, became effective in April 2021, but it's not automatic that somebody's misdemeanor, sentencing for a misdemeanor in April 14 is automatically gone, and somebody's felony in April of 2011 is automatically gone. They are running behind, right? And you mentioned that it will probably be not until 2023 before people who would benefit from this new law will start really seeing the results.
Yeah, and it may be that there are a few people that are going to see some changes, but they have to go in to every criminal record and see who has the eligibility and, you know, get that system in place. And they are, the news is reporting, the Office of the Governor is reporting, the Office of the Attorney General is reporting that it's likely going to be 2023 before we see the bulk of these things being removed.
Okay. And again, for somebody to qualify for automatic expungement, if it comes to a misdemeanor, and let's assume for a minute, it's the kind of misdemeanor that will allow you for an automatic expungement, you have to have been sentenced at least 7 years before, and you have to have had your record clean since.
Yes, absolutely. Nothing pending and no new convictions for 7 years for the automatic expungement.
So that's an important thing. Yes, you have to wait 7 years to prove to the law that you deserve your record to be expunged, because it's been 7 years, and most importantly, because your record has been clean since.
Yes, and that's we've discussed that before. It's a good public policy to make sure that, you know, you're not just getting sentenced and automatically, you know, a few months or a year or even 2 years later, they're not giving you a chance to see you're not giving them a chance rather to see that you really are serious about changing your lifestyle and that you're not going to be committing any more crimes.
Right. Very good. Now, before the law change, you could only, and correct me if I'm wrong, before the law changed, forget that. With the new law, you can only wipe out up to only 4 misdemeanors, as long as, again, they're older than 7 years and you've been clean for 7 years, right?
For the automatic process, yes, that's correct. Up to 4 will be automatically expunged if they qualify.
Okay. And under the new law, you cannot expunge more than 2 felonies, as long as they're older than 10 years and you've been clean since.
Yes, again, with the automatic expungement, they will only expunge up to 2 automatic, those that qualify under the automatic, up to 2. That's right.
One thing we want to add to our listeners that we're only talking about the automatic expungement laws. Nothing prevents anyone who's listening to, I say hire a lawyer, and I'm going to say why in a minute. Hire a lawyer and file an application in front of the judge for an expungement. That's different than automatic. Automatic means you don't have to do anything. It will fall off. But Unless it is a misdemeanor or a felony that does not qualify, you can always file in front of the judge and have the judge hear your case, and the judge, in her or his mercy, will decide whether or not your record for that felony or that misdemeanor is wiped out. Now, the reason I said you ought to hire a lawyer, and you've made that point, I believe, on more than one occasion. When you file an application to have your record expunged, file an application. Again, we're not talking now about automatic expunsions where you don't have to do anything, it's just waiting. It's a waiting game. If you want to file, you really should hire a lawyer. Why? Because you have only one chance to get it right. Again, let me repeat. It's not like you can try and try and try again. The law gives you only one chance to file in front of a judge and try to convince the judge to expunge your record from that felony or misdemeanor. Maria has told me in the past, and correct me if I'm wrong, that there are quite a few procedural hoops you have to jump over to make sure your application is correct. The last thing you want is try to save a little bit of money and do it yourself, sabotage your application, and now, unless the judge allows you to withdraw, which does not happen very often, you lost your one and only chance.
And that's right. That's absolutely right. If they rule and make a final decision on the application that you filed, and they rule to deny your application based on any type of technicality or missed procedural, course of action that you may or may not have taken, your application has been ruled on. And once it's been ruled that you are not allowed to set aside that conviction, you cannot apply again.
Right. I want to talk about driving offenses in particular. A lot of driving offenses, they will apply if they result in a misdemeanor. They may be automatically expunged. However, any traffic offense, any ticket you get while you are driving that results in bodily injury. So, for example, you're in a car accident and the officer deems that you were speeding, gives you a ticket, and because you were speeding, you caused an accident, and now the other person is injured. What about if you are injured? Does that apply too? Or it has to be bodily injury to other?
It would normally, you wouldn't be cited if you were the person that was injured. For a accident involving death or injury, is usually the other person. I don't think I've ever seen somebody get cited for their own injury.
Okay, so let's say someone is driving and they violate driving laws by, improperly turning right when there is no right turn, or crossing the red light, or speeding, or reckless driving, or anything. If that person gets a ticket, and if in that accident you caused bodily injury to another, bodily injury, not just property damage. We're not talking about to the car or to poles or anything like that. Bodily injury. If you have caused bodily injury, guess what? It's that kind of an offense, which may or may not be a misdemeanor, depending on what it is. Reckless driving is, but speeding is not a misdemeanor. But do know that this driving offense is never, ever, ever automatically expunged. Under the new expungement laws, not every violation is expunged, not every misdemeanor is expunged, not every felony is expunged. But here, I think Maria wants the listeners to also know, however, you can apply the old-fashioned way by filing an application, filing a motion in front of the judge, hopefully hiring a lawyer because you don't want to get it wrong. You get only one chance at it, and seeing if the judge will waive it. So, yes, it's not going to be wiped out on its own. And by the way, if it's a driving offense that is neither a misdemeanor nor a felony, is there still a waiting of 7 years?
Well, if it's not a misdemeanor, it's not a felony, it wouldn't be on your criminal record. That would be something that would be more applied to your driving record, which the Secretary of State has after so many years, your tickets fall off. So if it's just a ticket and you're not being cited for a misdemeanor, then there's no need to have it fall off your criminal history.
Okay, but if a driving offense causes bodily injury, then it's my understanding that you will never have it automatically expunged.
Correct. Right. But it would have to be a misdemeanor for it ever to hit your criminal record.
Got it. So let's clarify that. A driving offense where you are charged as a misdemeanor, and if it causes bodily injury, if you can be recklessly driving, but you did not cause bodily injury, then that's different. But
correct.
If you have a driving offense that is a misdemeanor and that causes bodily injury, that's the kind of misdemeanor. You can wait 7 times 77. It's not going to automatically fall off. But nothing prevents you from consulting with a lawyer to see whether you are a good candidate and perhaps applying before the judge and having the judge look into it. That will cost you money versus automatic expungement where you don't have to do anything.
Yes, absolutely. And there are going to be some that are not going to be applicable for an application. If you were drinking and driving and you caused death or injury, that's likely not going to be expungible. But there are certain, like your example of reckless driving. While it won't fall off automatically, definitely call and consult with an attorney, take a look at your record and see if whether or not you can try to get it expunged through, like you said, the old-fashioned way, file an application under the new laws.
Okay. Now, just very quickly with the 4 minutes remaining, some things you can never discharge them automatically, even if they are misdemeanors. Like every general rule has exceptions. And again, we said up to 4 misdemeanors, as long as they're 7 years old and your record is clean, great. But some you can't. You can wait 7 years, 14 years, 28 years. They're not going to automatically fall off. For example, the misdemeanor of crime of theft and dishonesty, also called retail fraud. That is not the kind of thing you can be convicted of and wait 7 years and expect it to automatically fall off. It will not. Domestic violence, first offense and second offense, you can wait 7 years and 14 years. It will not be automatically discharged. Now, are these the kind of things you can apply in person in front of the judge, or are they also like drunk driving? You can't.
Well, with the new clean slate bill, you can file the application.
The law is, by the way, the law that we're talking about is called the new clean slate bill. Yeah.
Yes, and with it, they actually in October did expand it to first-time drunk drivers for application only. That is correct. These are not going to automatically fall off, and you can wait a lifetime to see if they will, and they will not. What's going to happen with those types of crimes, if you'd like a chance to expunge your record, you still have the ability to try. You just have to file an application. And you will have to qualify under the other set of rules, which we don't have time to go into today, maybe on another show, but for the application. And the application has its own set of rules, timeframes, and procedures. But there are a host of different felonies and misdemeanors that do not qualify under automatic, but will qualify under the petition. And then, of course, there are some that you can just never get off your record, Joumana.
Sure. And again, you said that so many times. This law is funny. The law is so funny. The way it's written is so funny. It's kind of confusing a little bit. And it's new law. So even you lawyers, criminal law attorneys, you're still trying to figure out that law, correct?
Yeah, we're just and because it just passed in April, we haven't even seen a court date yet because, they set them 3 months out. So once you file a petition and you hire an attorney to do it, it takes 3 months to get that court date. So it's definitely not been heard yet.
What are you talking about? An automatic expungement does not require a court date.
No,
It does.
just for the petitions, when you hire a lawyer for a petition.
Okay, because you're saying that the new law that passed in April not only gave the right for some misdemeanors and felonies to be automatically expunged, but also changed the pre-existing laws on petitions.
Absolutely. It expanded it in more ways than one. The timeframes have been shortened, and the amount of felonies that you can expunge and misdemeanors you can expunge are much greater now.
Okay, so the media has been mostly talking about the automatic expungements, and very little has been said about the other part of the law that changed in April for, when you do it the old-fashioned way. But obviously, with less than 1 minute remaining, we're not going to talk about that. It was an amazing program, amazing information, like always. Thank you so much. Thank you to all of our listeners, to those who sent questions. Rami, thank you, and see you tomorrow.